Representative Hudson moves House File 3822 before the committee with a recommendation that the bill is re-referred to State Gov Finance Committee. There is an amendment that has been filed with the bill, but we will consider the amendment after Representative Hudson has presented his bill in testimony. Representative Hudson, begin your testimony, please.
Thank you, Chair Novotny and Chair Moeller. You'll note that fiscal notes being passed around to this bill with a cost of $0. House File 3822 makes a adjustment to the level of offense that's already codified in 609.43, misconduct of a public officer or employee. What it does is it says that a person who violates paragraph A may be sentenced to imprisonment for not more than 1 year or a payment of a fine of not more than $5,000 or both. So we're basically taking this from a gross misdemeanor to a felony for the 4 different circumstances outlined in lines 1.11 through 1.19 that, again, are not changing from existing law. This is simply an adjustment to the level of the offense and the consequences that would be endured by somebody convicted of committing this offense. I'd like to draw a particular note to lines 1.18 and 1.19 in the capacity of such an officer and employee that makes a return certificate, an official report, or other like document having knowledge it is false in any material respect. And this, of course, evokes the story that came out of KSTP on January 6th of this year, where the Minnesota Department of Human Services Commissioner said the agency is investigating after the legislative auditor found employees in the agency's behavioral health administration backdated or created documentation during an audit that focused on the management of taxpayer-funded grants. The revelation came during a nearly 3-hour hearing when Judy Randall, the legislative auditor, told lawmakers that her staff found multiple instances of what appeared to be an attempt to fabricate documentation that didn't previously exist. Randall described it as a systemic effort that she said she'd never seen in nearly 3 decades with the Office of Legislative Auditor. The quote was, "We have never been able to prove it, to document it, and we did in this case." I have not heard any updates from DHS regarding the outcomes of that investigation or whether or not there's been any appropriate disciplinary action, but we do have this statute on the books that specifically calls out what took place in that case as an example of something that should carry criminal penalties. And for whatever reason, those cases have, to my knowledge, yet to be brought. But if they are, that type of behavior, I think, is well beyond the pale of what's expected from the folks who we pay with taxpayer dollars to administer the business of this state. And I would appreciate the support of the members of this committee to update the consequences for this offense. Thank you, Mr. Chair.
Thank you. We have an amendment A1. Who has the amendment?
I do, Mr. Chair.
Chair Moeller, describe your amendment.
Yeah, thank you, Mr. Chair. And I do plan on withdrawing this amendment, but in looking at the language of the current law, and obviously applies to state employees, and I certainly, understand conduct that is troubling. But as I was looking at this, as we were talking about it, we recognize that we have an issue with federal agents not complying with what they're required to do under law. And I was especially thinking about what the judges have been saying to the attorneys who are appearing in ICE-related cases. I believe there are over 96 court orders that ICE has violated across 74 cases. There are particular cases where ICE or where the judges said that people needed to be released on bond, and the federal employees said they just hadn't gotten around to that yet. Clearly, these are things that they are required to do, and they weren't. And so it just, again, just wanting to point out that this is an issue at the federal level right now. And with that, I will withdraw the amendment.
With that, Chair Moeller withdraws her amendment. Questions for Representative Hudson?
I believe there might be a testifier.
Stand by, we have a testifier. Devin Bruce, Legislative Director of Political Affairs at MAPE. Mr. Bruce, identify yourself and begin your testimony.
Thank you, Mr. Chair and members. For the record, I am Devin Bruce, the Director of Legislative and Political Affairs for the Minnesota Association of Professional Employees, a union representing over 18,000 workers across all agencies, boards, and commissions. I just want to thank you for the opportunity to testify and share some of our concerns around some of the language around the expansion of criminal liabilities contained in House File 3822. We also share the concerns that are highlighted in MMB's letter, particularly in your packet, such as the impact that this may have on state employees' rights to due process, as well as a fair investigation, as well as the progressive discipline structure that would more appropriately fit any of the alleged misconduct after the investigation. This bill, however, also jeopardizes some of the other things that we've been able to accomplish over the past couple of years in expanding some of the whistleblower protections, as well as creating stronger regulations and processes for our state employees to report and stop fraud. The number one question that we've been asked and that the public has asked is, whenever we have these hearings on fraud regarding some of the conduct from private nonprofit entities, is why did the agency continue to make payments if there were suspicions of fraudulent activity? And in some cases, like Feeding Our Future, employees did just that. They did stop payment only to be later directed to resume the payments and reimbursements amid sustained legal and harassment campaign by the organization. Under this bill, which an employee who attempted to do the thing that everybody is expecting and asking them to do and stop payment could then be subject to enhanced criminal penalties for failing or refusing to perform a known mandatory, non-discretionary ministerial duty of the Office of Employment. That is in subsection 1 of A under this provision. Over the past couple of weeks, we've heard many quotes pulled from Judge Tim O'Malley's report regarding the investigation concerning the culture of compassion over compliance, where top DHS officials ignored the program integrity concerns brought by employees and also whistleblowers that you've also heard in the fraud committee or that have heard from your own constituents. These rank and file employees would then be subject under this proposal to some of those penalties, and not the people who above them who may have directed them to perform this misconduct. It almost always falls on the rank and file employees and not the ones who are at the top. They always avoid accountability. And we undoubtedly know that this will also have a chilling effect on any more whistleblowers who would attempt to come forward to share their concerns because of the word felony. We've had this experience in the past, or fears of litigation being brought against them, or undue harassment. So we all have an interest in holding people accountable for their actions, particularly public employees. Any misconduct undermines the integrity of the programs that they're hired to perform and the investments that all taxpayers make in these programs and that they rely on. So we would appreciate that you take a much more narrow approach to this rather than broadly applying prescriptive punishments that would violate public employees' due process rights, as well as have serious chilling effects on a progress that we've made over the past couple of years. And thank you.
Representative Hudson?
Thank you, Mr. Chair.
You look like you have a thought.
Sure. In response to that, I'll just say it's a little bit difficult for me to follow the argument because there's no structural change to the underlying statute in terms of how it functions or what it is aimed at addressing. I was particularly confused by the statement within the MMB letter that says the statute covers many different kinds of conduct from serious abuse of power to, quote, procedural mistakes. I'm looking through the existing statute. I don't see any reference to procedural mistakes. Again, I will read off the 4 areas where this law would apply to you as a public officer. 1, intentionally fails, or refuses to perform a known mandatory non-discretionary ministerial duty of the office or employment within the time or the manner required by law. Or 2, in the capacity of such officer or employee, doesn't act knowing it is in excess of lawful authority or knowing it is forbidden by law to be done in that capacity. Or 3, under pretense of color of official authority, intentionally and unlawfully injures another in the person and another person's property or rights. Or 4, in the capacity of such officer or employee, makes a return, certificate, official report, or other like document having knowledge it is false in any material respect. Those are the ways you fall under this criminal statute that, again, already exists as a gross misdemeanor. There's nothing in here about making mistakes. There's nothing in here about making errors. There's nothing in here about being an imperfect human being who occasionally makes a typo. This is about knowingly and intentionally abusing your power as a public official. It's already a gross misdemeanor, and we are simply adjusting the seriousness with which we address that on the consequence side of the equation. There's really 3 areas that apply to situations like this. The first is investigations, and then there's oversight, and then there's consequences. This addresses the 3rd leg of that stool, which is the consequences. It also does not prohibit or interfere in any way with the progressive discipline structure, which of course is an employment concern as opposed to a criminal concern, which falls in a separate silo. If activity warrants somebody being dismissed, that's a separate consideration from whether they have broken the law.
First up for testifying is Representative Duran.
Thank you, Mr. Chair. Maybe this might be for Mr. Bruce, but I was just trying to figure out here. During your testimony, you said that if someone is mandated, like the rank and file person is mandated by an employer to do something illegally, what do you tell your employees? Because right now, I mean, what I've heard from you is that usually what happens is that order comes from the top and then it pushes down. Even though it may be illegal, the employee's still doing it. So I'm just trying to figure this out here. And through your testimony, it's a concern to me because I don't think that this bill says that your rank and file person has to violate the law. Actually, it's just saying it's more of an increasement of the penalty when someone knowingly violates the law. So I guess I'm a little bit concerned on the testimony here, and for the employees and obviously your people's safety. I want to make sure that they're not being forced into violating the law as well. Can you explain that a little bit for me?
Mr. Bruce.
Yep. Thank you, Mr. Chair and Representative Duran. My testimony in particular was on this, the broad construction, particularly under section or subdivision 1 of section A. And because that is a ministerial required duty, so it's essentially what your job performance would be. In many cases for our employees who are administering grants, it's remitting the money. So if there are broad concerns and they aren't being listened to, this culture of indifference or noncompliance is allowed to permeate through some of the agencies, or at least in part with some of the supervisors. If they are told to do something, they either face discipline for, in some cases it would be, I'm trying to think of the word. They would face discipline for not following direction or from their supervisor, or in this case, if they knowingly do it, there might be some type of other consequence, in particularly like a felony. We've seen areas where it's pretty gray in the past, and we've done a lot of work to try and clarify where state employees can refuse to remit certain grant payments to either legislatively named grantees, or in other cases, places like Feeding Our Future or some of these others that have been named, where they have some suspicion of fraud or some concerns that the paperwork is not being submitted on time and they're told to do it. If they refuse, then this statute says that they aren't performing their ministerial duties and could be subject to punishment.
Representative Duran.
Thank you, Mr. Chair. This next question's for, or thank you for that explanation. I don't know if the the bill does that. But Representative Hudson, what is changing in this bill?
Representative Hudson.
Thank you, Mr. Chair, and thank you, Representative Duran. I appreciate that question. The structure, whether we agree with it or not, that's been referenced in lines 1.11 and 1.19 is not changing under this bill. It's an existing structure. So if it is indeed too broad, then I guess we need another bill to address how broad it is. I don't believe it is too broad. What we are changing in this bill is the severity of the consequence for being found guilty of this criminal provision, misconduct of a public officer. And I'll also just note, in reference to the suggestion that this could suppress a state agency employee from taking appropriate action in circumstances where they suspect fraud is taking place, a couple of things. First of all, the language is very clear that known intentionally, there's an intention here to do something that's illegal, that's unlawful. If there's ambiguity in the context of instruction you've been provided from a superior as to what your appropriate ministerial duties are, I have to believe that both prosecutors and judges would take that ambiguity into consideration as they adjudicated a claim that a public officer was guilty of this particular criminal conduct. Secondarily, in my role on the House Fraud Prevention and State Agency Oversight Committee, I and my fellow members have been privy to multiple whistleblower complaints. And of course, we have Faye Bernstein, who's come out publicly and put her face and her name to very alarming accusations of retaliation for doing precisely that, for saying, hey, there's red flags here and we need to do something about it. I have yet to encounter a single whistleblower who said, you know why I'm a little anxious about coming forward with my observations? It's because of 609.43. It's because I'm afraid I'm going to get convicted of a gross misdemeanor for telling you that fraud is happening. It's never happened in my experience. I do not believe that this statute, as it exists today, is any factor in whether or not a state agency employee is going to come forward. What we've heard from them directly is that the actual factors affecting whether or not they're willing to come forward or put their name and face to their claims is the fears of retaliation that they will get from within the state agencies.
Representative Duran.
Thank you, Mr. Chair, and thank you for that clarification. That this bill is not actually changing the structure, the statute that's actually in place right now. It's actually just increasing the penalty of someone that's knowingly created a criminal action already. So, I mean, it's pretty simple, pretty clear, and I think we all should be able to support this. Thank you.
I will just say, my daughter used to play volleyball, and they had a rule in volleyball is that if there's any question if the ball is going to be in, it's in. You don't take a chance, and you report it. And I think that, if there's a chance something might be illegal, it's illegal. Representative Rapinski.
Thank you, Chair Navani. I kind of listen to what you say to our testifier. You use the term above them that may have directed them, and you use the example of feeding our future. When you use that example, and you talked about payments were cut, and then payments were then reinstated, I guess I'm assuming that came from above them. Have they been able to identify who instructed them to reinstate it or why they were reinstated after they were kind of found to be fraudulent to begin with? Have they been able to properly identify that chain of command, or, as you said, above them may have directed them?
Representative Hudson.
I believe the question was directed at the testifier. I defer to the testifier, sir.
Mr. Bruce.
Thank you, Mr. Chair. And Representative, there has been numerous conflicting accounts, but from what was at least stated from the judge who oversaw some of the case filings, that there were settlements reached between the agency and also the recipients of the grants when there were discrepancies. So at some point, it was either settled outside of court, pending a court filing, but in some instances, there was also reports that during some of the hearings, the judicial officer instructed the grants to be turned back on. And so that's where we see some of these conflicting accounts, and our employees then just do their job as they're supposed to.
And if I may add,
Representative Hudson.
Mr. Chair, I very much appreciate that point being brought up, because indeed, specifically with Feeding Our Future, the reason why the payments were restored was because of a court order, as the individuals involved who would go on to be indicted and convicted in that scam were actively litigating against the state agency.
Mr. Rapinski.
Thank you very much for that. And knowing my constituents, one of the biggest questions I receive is what is going on with all the current fraud that's being explored and being whistleblowed upon, and who's being held accountable for that. And I do believe this bill is a good measure to help in that. So I am supporting this bill, and thank you, Mr. Hudson, for bringing this forward. Thank you.
Representative Curran.
Thank you, Chair, and thank you, Representative Hudson. Just a couple questions. I'm looking at how the current statute is used, and sort of looking at how the makeup of cases that have been charged versus cases that are convictions. I'm not seeing a ton of information on anything related to fraud. I'm curious if you have had conversations with, I know we had one union rep is here with MAPE. Have you had conversations with law enforcement associations, MPPOA, LELS, chiefs, sheriffs about this bill?
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Curran. No, I have not had any conversations about this specifically, because we're not dealing with any substantial change to the existing structure of the statute, just the criminal penalty.
Representative Curran.
Thank you. And yeah, I think they might have some opinion on this. I guess we'll find out. But when looking at the 12 convictions under this statute that have happened over the past 5 years, 6 of them are convictions for on-duty officers. And with an increased penalty to a felony, some things like misusing a city-issued credit card or looking up a woman at their gym, that would bar them from having a firearm for the rest of their life. And so I'm curious if law enforcement is present, or if they might have an opinion to offer, if they're comfortable knowing that half of the cases that are charged involve some of their members, and they would lose the ability to carry firearms for that.
Representative Hudson.
Thank you, Mr. Chair. Are there any such individuals who could testify to that? I'm not seeing any. So what I'll say is, from my perspective, I couldn't possibly care less, right? If they're guilty of those offenses, and that's the consequence under the law, they should endure the consequence.
Representative Curran.
Fair enough. Thank you.
Representative Tabke.
Thank you very much, Chair Novotny. I, too, when I heard about the news of the DHS employee, I was extremely concerned about that. It is a big problem that we need to be making sure goes through, and so I scheduled meetings to talk through it with folks and find out what is happening from a state level, how it didn't, because coming from a city background and having been mayor, like it would have been very much handled quickly, and I wanted to make sure that the same kinds of things were happening at the state level. And so I had a meeting with the legislative auditor a couple weeks ago to see if there's any legislative changes that we needed to make in order to make sure that if this kind of thing happens again, that we have activities in place to take care of it. And so from my personal perspective, I'm waiting to see what happens with this and how it moves forward. So I'm just going to let you know, from the beginning of your testimony, you talked about how you didn't know where things were at on that, but I just want to let everybody know that what DHS, as they've reported multiple times, on the 18th of December, they learned about it. The evening of the 18th, they met with OLA to discuss the issues. The 19th, they worked with the compliance office. 23rd, they started the investigation, developed a plan. So we're in phase 2 of the plan right now and I think that employees deserve due process and making sure that we're getting through things. So I don't support what you're doing in the bill here today, but if you have other ideas and want to work on things, would be happy to work on them with you and find a way to get forward, because this kind of thing, absolutely, I agree with you entirely, should not happen. I just don't think this is the right fix for it, so thank you.
Response?
Thank you, Mr. Chair. I'll just point out that, again, citing the KSTP story, Judy Randall, the legislative auditor, told lawmakers that her staff found multiple instances of what appeared to be an attempt to fabricate documentation that didn't previously exist. Randall described it as a, quote, systemic effort, unquote, that she said she'd never seen in nearly 3 decades with the Office of Legislative Auditor. To me, that suggests this was not one bad apple. Systemic efforts are not one bad apple. And so it does raise the specter of, how are we here in March and we still don't have an update from DHS as to, first of all, who was responsible, whether or not they've been disciplined, or apparently any effort to pursue criminal charges under the existing 609.43 statute that we have currently, which is available. They could be brought up on gross misdemeanor charges right now, and likely properly should be. And perhaps the reason there's been so few cases historically is because it's a gross misdemeanor. We do know that prosecutors take the level of the offense into account when they use their discretion to determine whether or not it's worth their time.
Vice Chair Feist.
Thank you, Mr. Chair. I'm looking over the statute and just thinking as an employer about line 1.16, so just the original underlying statute that this would cover, where somebody can intentionally injure another person's rights. And that just is so broad. I honestly don't know if that should exist at all. It seems like incredibly broad, and just employment law is so messy. So I think, a manager who hurts somebody's feelings and they feel like those feelings were their rights, and then, something where it's just like maybe some poor communication skills or miscommunication and lots of feelings becomes a felony. And that seems like wildly outsized consequences for just kind of maybe being a crummy manager. So yeah, just taking it out of the realm of all of the bigger picture questions, I just think that the felony consequences for a scenario like that seems outsized to me. Thanks.
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Feist. I certainly hope and trust, actually, that our judicial officers are not so subjective and loosey-goosey that they would take a hypothetical like that and regard it as an actual intentional violation of some person's rights. But again, we keep going back to lines 1.11 through 1.19, which again is underlying statute. And I do appreciate the fact that changing the gravity of the offense changes the dynamics of how it's applied and perhaps how often it might be applied. But if we need to take a look at the underlying statute in order to refine definitions, I think that's a task for another bill.
Vice Chair Feist.
Thank you.
Chair Pinto.
Thank you, Mr. Chair. Representatives and members, I've made the point in a couple bills that we need to be thinking about how the penalty for a given offense kind of fits in the broad structure of offenses, right? So under current law, an assault against a family or household member is a misdemeanor. So a domestic, and we obviously in this committee taking domestic assault very serious, it's a misdemeanor. We say in our current law that a public officer or employee who does one of these things under current law, and has been noticed, very broad conduct, a lot of different things could fall in. That's a gross misdemeanor, because this is a public trust that public officers and employees hold. So already when somebody does this, it's quite a serious offense. If there are 2 domestic assaults, that's a gross misdemeanor. That's equivalent to what the current law is. I get concerned about increasing the penalty to a felony. In part, what it does is then devalues other felonies. So we're saying that this broad conduct, so again, the misuse of a credit card, to use just one example from the list that we have, that is more serious than assaulting a family household member multiple times. It's more serious than a non-consensual sexual contact, which is a gross misdemeanor. It's more serious than indecent exposure. It's more serious than torturing an animal that does not die. Representative Hudson, you made the point that well, maybe one part of the reason that there are relatively few, or you'd think there might be more prosecutions if this is made a felony. In my experience, it's the exact opposite. Felony has a 12-person jury. Misdemeanors, gross misdemeanors have a 6-person jury. And to charge a felony, that's a very serious thing as well. It should be. In my experience, it's actually much more common. When in doubt, you're going to be able to go with a misdemeanor, gross misdemeanor. So I think you're going to find it's going to be less often that this is going to be charged once you make it a felony. More than half the people charged or maybe convicted of this crime were first responders. Most of them police officers and also firefighters. So, we could impose more felonies on first responders if that's the point here, because that's what the situation has been. Again, misuse of a city-issued credit card. Somebody who applied for a job interview and falsified the licensing certificate when they did that. That's a firefighter. Now, is that misconduct? Absolutely. And is that worthy of a criminal conviction? Absolutely. Is that more serious than non-consensual sexual contact? Is it more serious than repeatedly assaulting one's romantic partner? I don't know that it is when you look at all the consequences of a felony. And again, every time we make something a felony, it makes the current felonies be worth a little bit less. And so we want to think about whether we want to do that. So given how broad the language is right now for ways to violate this statute, and a reminder, if fraud is committed, if theft is committed, there are separate offenses to charge that, depending on the value and all kinds of things. So there's many other ways to charge somebody with a crime and to have them be convicted of a crime. So this is separate from that. So is this conduct well situated in our framework of offenses? I would argue that it is, and that making it a felony would not be appropriate for what is listed here when we're just considering those particular situations. If there's something that violates another statute as an offense, then we treat that the way that it is. But we want to be very, very careful making things felonies along the way. So I appreciate your intent here and absolutely recognize the public trust that these folks hold, and they should be held to a higher standard, and in fact, they are. We should go after anybody who's misusing their office, as the law currently allows. Thank you, Mr. Chair.
Thank you, Mr. Pinto. And before you get a chance to respond there, Mr. Pinto, with great responsibility comes great penalty. Higher penalties, as you said. A lot of public safety officers, police officers are responsible for getting charged under this bill. And if they have, they should. Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Pinto. I'm not sure I agree with the premise that there's some sort of metaphorical limited pool of seriousness, and that every time we create a new felony, we diminish the total capacity of that pool, and all other felonies are suddenly less serious because we recognized a new crime. I don't follow that logic. I think what we do is we look at the individual conduct, and we determine how serious that conduct is in its context, and then come up with penalties that are just and that will tend to result in deterring that conduct from recurring in the future. And as Chair Novotny and you yourself, Representative Pinto, noted, we properly should take into consideration the power differential, the power that people have been entrusted with, the public trust, and an abuse of that, I think properly ought to be regarded as a higher violation than if a similar crime was committed by somebody who lacks that power and lacks that authority.
Chair Pinto, are we done?
Mr. Chair, maybe I'll just note that, and my point is that it already is treated that way. It already is treated more seriously. And so then the question is, do we want to treat it sort of double more seriously? And at some point, I think we say, hey, we are treating it more seriously. It fits in our framework of crimes. It's appropriate. We can obviously agree to disagree on this, but that'd be the point I'd make. Thank you.
Representative Pinto. We've got a list, Representative Rapinski. Representative Johnson.
Thank you, Chair. First, I just want to say thank you to the testifier for coming up and being here, advocate for the folks that you're representing and the workers that are, the vast majority of them, doing the right things. And to that point of public trust, I've been a union officer for a long time, and I've told my members, because there are conversations that I've had with attorneys and issues I've had with grievances and arbitrations, where police and fire are often held to a higher standard because of that trust that we talk about. But when I also represent my members in different hearings regarding conduct or things that went wrong, the question I always ask is, what are we trying to do here? Are we trying to penalize the person and make an example out of them? Or are we trying to change the conduct so it doesn't happen again, whether it's them or somebody else? And what I always try to do is figure out how we change that conduct, because I don't want to continue to be in that room and continue to have those same arguments. And when I look at the current statute, the tools are there. The tools are there to try them, to hold them accountable with gross misdemeanors, and for some reason they are not being used, right? So we are not changing it to a felony is not going to change the conduct. And I've heard it in a bunch of different committees that criminals are going to be criminals. If they don't care about the penalties, they don't care about this or that, criminals are going to find a way to be criminals. And if somebody is going to violate a policy or do something like that, I think figuring out how we address it on the front end is going to be way more productive in how we deal with it on the back end. So I guess if I'm going to try and boil it down to a question, the tools are already there and they're not being used, or they're not being used successfully. So how does just changing it from a gross misdemeanor to a felony actually solve any of these problems?
Representative Hudson.
Thank you, Chair Pinto, and thank you, Representative Johnson. As I noted, this is not a comprehensive overhaul of how we deal with these issues, such as the one that's described in the KSTP article. There's three broad silos. There's investigations, there's oversight, and then there's consequences. And what you're speaking to, and I absolutely agree with you, there's something wrong with investigations, and there's clearly something wrong with oversight if we're not seeing the current underlying statute applied to circumstances which it was very obviously and directly authored to address. And I don't have the answers to those questions, and this bill does not provide an answer to that question. When we're considering consequences, it's a question of how seriously do we take this offense. And when I look at what was reported earlier this year, a systemic effort to attempt to fabricate documentation within a state agency, that's pretty dang serious. And when we're considering what the consequences for that ought to be, to my mind, making it a felony is appropriate.
Representative Johnson. Okay. Is there anyone else who would like to have a question for Representative Hudson?
What's up, Mr. Chair? Can I just ask one more question, Representative Hudson?
Chair Pinto, go ahead, and then I remember.
My only question is, Representative Hudson, why stop at a 1-year, $5,000 felony? Why not make it a 5-year, $10,000 felony, or a 20-year, $40,000 felony, or a 100-year, $1 million felony? Like, I mean, once you're gonna, I mean, yes, it's really serious. So, like, how are you choosing where to even stop?
Representative Hudson.
Thank you, Chair Novotny and Representative Pinto. It sounds like a deep philosophical question. How do we ever decide what penalties should be? And to your earlier point regarding, you know, the concept of felonies being in this kind of grouped category of mutual seriousness, I don't know that that's ever, and I could be wrong, but I don't know that that's ever been the approach that people have taken in bodies like this to determining what a sentence properly ought to be. You want to have a conversation about it being higher? I'm open to that conversation. I just think the current status of it being a gross misdemeanor is inadequate.
Thank you.
Representative Rapinski, did you have a quick question?
I do, Chair, thank you. I'm just listening to Representative Pinto over there. I'm curious if at some point maybe is his thought line of like the first offense would be a gross misdemeanor and then following offenses could be felony and the following offense could be potential longer sentence time? Is that what you're kind of getting at there? Is that like what you're supporting or was what I didn't quite, I want to make sure I'm following exactly.
Chair Pinto.
Thank you, Mr. Chair. So Representative Rubinski, yeah, I could imagine that could totally make sense. Yeah, I mean, as it is right now, somebody has multiple offenses, they do stack on top of one another, right? You end up getting additional criminal history points, you end up receiving a longer sentence. So, yeah, potentially. Basically what you want to do is look at the nature of the offense and then compare it to other offenses and find a penalty that fits. So I could certainly imagine that potentially a second offense could make sense. In this case, what it's saying is that that first offense is a felony, and then it goes on from there. Sure. And that, to my mind, is inconsistent with the other offenses that we have.
Representative Rapinski.
Okay, thank you.
Representative Steer.
Thank you. Thank you, Mr. Chair. I kind of like the year and $1 billion felony. That would be nice. With that, I request a roll call.
Representative Steer has requested a roll call. Roll call being requested, one will be granted. Vice Chair Whitty? Good. Passing. Co-Chair Moeller.
Thank you, Mr. Chair, and appreciate the discussion and certainly agree that the article describes very troubling behavior. I am curious, Representative Hudson, if you have any examples of this beyond this, what's mentioned in the article with the DHS employees?
Representative Hudson.
Thank you, Chairs Novotny and Moeller. The specific context described in the KSTP article, I'm not aware of other instances, and in fact, the article has the quote from the Office of Legislative Auditor Judy Randall, who says that in her 3 decades, she's never seen anything like this before. What I will say is that I think that it's reasonable to insinuate that for something like that to happen, again, a systemic effort to fabricate documentation, one could reasonably ask the question, under what sort of culture does that take place? And whatever the answer to that question is, how pervasive is that culture? Does it cross agencies? And how much stuff is going on below the surface that we are not currently aware of?
Chair Moeller.
Thank you, Mr. Chair. Well, you know, again, I understand what you're trying to do, but also with respect to DHS and those employees, this law can't be retroactive. That would violate the Constitution. So the effective date applies to crimes committed on or after the effective date, and so it couldn't even be applied to the situation that you're, you know, wanting to get at here. And agreeing with my colleagues that say making it a felony certainly doesn't make it more likely to be charged. I actually agree with Rep. Pinto. In my experience as a prosecutor, I think it would make it even less likely to be charged. And in particular, when we look at some of the cases, and a couple of my colleagues have mentioned these already, where there has been a conviction, we've got a case where a sheriff's deputy used the CJIS database to improperly access information about another deputy and an incarcerated person. That deputy was convicted. We had another case where a county employee was tasked with determining which citizens are eligible for government assistance, deleted dozens of voicemails and emails from those seeking assistance, seeming to ignore them. Both of those incidents are bad. They're not good. But I don't think either of those things should rise to the level of a felony. And I'm actually reminded in reading that last example of a situation when I worked at a public law office and we had an employee who, she got overwhelmed by all the mail coming in, and I'm old, and this is before we had so much electronic filings. But she got overwhelmed by all the mail coming in and just started putting it in a filing cabinet. And when she actually left the job, someone found all of this mail, and these are court cases, you know, that was pretty serious. And I really think for her, it was a matter of anxiety or a mental health issue. I certainly don't think that should rise to the level of a felony either. So for all of those reasons, I just don't think that your bill here is really getting at the conduct that we all don't like and want to solve. Thank you.
Thank you, Chair Moeller. The points you brought up, the examples you brought up are exactly why I think this is a good bill and why the increased penalties should be there. You talk about the deputies that were accessing information that they knew they weren't supposed to access and for the wrong reasons. There are certain penalties and prohibitions that kick in when you have a felony conviction, and maybe that's what it'll take to get their attention. Maybe they don't get prison time, but they'll still have that conviction and the restrictions that come in because of that. Closing comments, Representative Hudson.
Thank you, Chair Novotny, and thank all of the members for a robust conversation about this issue. As far as the effective date and it not directly addressing the alleged conduct from earlier this year, I don't think there's anything particularly unusual about that. We write laws in response to things that have taken place in the past that will not go back in time and fix those things all the time. We did it earlier this week, and appropriately so. Beyond that, I feel as though, you know, we've worn the topic pretty well through. The last thing I will note is that if it sounds like there is a potential appetite to take a look at the specific type of conduct that's noted in the KSTP report. So if this simple change is inadequate and there's something more comprehensive we can do, whether it's in this statute or another, open to that conversation.
The roll call having been requested, the clerk will take the roll.
Novotny,
Aye.
Moeller,
No.
Whitty,
Aye.
Feist,
No.
Berg,
No.
Bliss,
Aye.
Curran,
No.
Duran,
Aye.
Engen is absent. Greenman,
No.
Harder,
Aye.
Hollins,
No.
Hudson,
Aye.
Johnson,
No.
Pinto,
No.
Ream,
No.
Rapinski,
Aye.
Schwartz,
Aye.
Steer,
Aye.
Tapke,
No.
There being 9 ayes and 10 nays, the motion does not prevail.